Welcome back. Yes, indeed. Continuing our conversation, we're joined now by Mr. Agbakoba, who is a senior advocate of Nigeria. He joins us virtually. Good morning, and thank you for joining us on the program this morning, sir. And it's getting us to stay on this development between the EFCC and the former governor of Kogi State, Mr. Yahaya Bello. There's been a lot of back and forth as to what is the appropriate legal position. Different interpretations are out there. So could you tell us, what is your understanding of what the legal processes are concerning his arrest? Because there are some who think, yes, it should be. Others think, well, there are certain procedures that need to be adhered to and that EFCC may need to reconsider. So what do you think of this whole matter?
Thanks for having me. I really would stay very narrow on the legal and judicial questions. I wouldn't go into the drama of EFCC, the governor of Kogi State. But let me just give it some context to show where I think the problem is coming from. Now, when the EFCC was established, it was established under the tenure of General Obasanjo when he was president, and the bill is perhaps the fastest to pass the National Assembly. It passed in 2 days because there was pressure from the Financial Action Task Force for Nigeria to comply with international financial regulation standards. So that passed with a lot of errors and mistakes, which is plaguing us today. That's one. Two is the fact that, and I told the then chair of EFCC, Mr. Bauer, that the EFCC, by definition, is the Economic and Financial Crimes Commission. It's got nothing to do with corruption. Corruption is actually the job of the ICPC. So that has caused a lot of confusion if you go back 20 years in the war against corruption. But the real problem here, I think, is the rule of law, respect for court decisions. And as I understand it, I don't have first information, but as I understand it, the governor or ex-governor had gone to court and obtained an order to restrain EFCC from arresting him. In turn, the EFCC also approached the court and got an order to arrest the ex-governor. So, conflict. And I think this is the point that the CJN has continuously emphasized, that courts must refrain from giving orders that are in conflict. And again, as I understand it, the judge that gave the order to EFCC to proceed had before him the preliminary application filed by the ex-governor showing that an order from another court had been received, the concurrent court. So I would have thought, in my respectful view, that what the judge who gave the order in favor of the EFCC should have done is to say, look, I cannot give this order because my brother judge has given an order. And as I understand it, the EFCC also appealed the order from the ex-governor. So this conundrum is the cause of the problem. And the CJN has emphasized this time and time again. Will judges please stop giving conflicting orders? So that's the source of the problem, if you ask me. Okay,
well, we came across some write-up by Mr. Jibrin Okutakpa SEN. He says, while it is true that such applications was filed, and he filed it, which I'm reading from his text, it must be stated clearly that as of 17th April 2024, the applications he filed was overtaken by the decision of the same High Court of Kogi State, which made the order. And then he then went on to say that as from 17th April 2024, there were no more orders or orders of any court of competent jurisdiction stopping EFCC from inviting, arresting, or prosecuting Yahaya Bello. He then went on to say in that text, some of it I'm skipping, he says, let it be known that the appeal before the Court of Appeal has become academic and odious because the lifespan of the orders made by Jamil J on the 9th of February 2024 was pending the hearing and determinations of the originating motion on notice. The originating motion, as I said, according to him, was duly heard and determined on the 17th of April 2024, and Jamil J ordered accordingly.
My response is my brother, Leonard Silk Okuteba isn't a judge. It may be true that an order that has a lifespan has expired, but it is not for us to determine that expiration. It's for the judge. So to the extent that the application was granted by the judge, rightly or wrongly, not to arrest the ex-governor, rightly or wrongly, stands. The only way to deal with that order is to go back to the judge and to say to the judge, these are the reasons why I think the order ought not to have been granted. So I disagree with my brother Okuteba that the order had expired. No, he must go back to the judge and bring that to his notice. So I strongly believe that the second order that the EFCC obtained was wrongly applied for and wrongly granted because it conflicts. Actually, in the body of benches of which I'm a member, we have a panel headed by the former CJN, Mr. Justice Onogen, dealing with this huge problem. And we've seen it in the election petition cases, conflicting decisions. In fact, in one terrible case, the same appellate court gave a decision in favor of both the appellant and the respondent. So this ridicule has the effect of making us look, dramatic. What should Mr. Bello obey or what he shouldn't obey? But I'm not interested in going into all that. All I'm saying is that can we put our hearts in order, we in the legal and judicial community, by respecting the rules of law? If a judge grants an order, rightly or wrongly, you challenge it, or you apply to set it aside. You cannot decide for yourself that you will not obey it, which is what Mr. Okuteba is saying. It's clearly wrong.
I think part of what he also suggested was that the judge ruled that if the commission gets an order from a superior court, then they have reasons to invite him. And so granting this order meant that they had fulfilled their own part of the law, that there was no judgment whatsoever that stops them from proceeding, and that they had followed through with every legal requirement, and he doesn't see any reason why the former governor, who himself applied at that time, challenging all of these orders, to then say that first he wasn't aware, he wasn't served, and he wouldn't obey this one, or he'll hide from them being arresting him, and things like that.
Yeah, I think I really have answered that. I've just said that in the hierarchy of courts, if you approach the court and a judge makes an order, rightly or wrongly, you come back to that judge to show cause why that order should be discharged, which is what EFCC should have done, or appeal. But you cannot leave one court and go to the next court and make two judges clash. So I think that it will be proper to say here that the second order obtained by the EFCC was obtained in complete due process of the first order. That's my position.
So is it, since this order subsists now, is it then, would it be appropriate for the former governor, if they argue that, well, we can't obey this court, we can't show ourselves up in court or give ourselves up for arrest because there's supposed to be an order stopping the commission from arresting us?
Sorry, can you repeat the question? I really didn't hear you.
In light of this current order that the EFCC say they've got, can the former governor or his agent say the former governor cannot be arrested or show up to be arrested because of the previous order that they have, which they say stops the commission from inviting or arresting them, citing that particular one against this one that EFCC say they have?
Well, I'm having a challenge.
Can you hear me now?
You because
is it clear now?
I can hear you, but it's all. Yeah, I can hear you.
Okay, so is it right for the former governor, would it be legally correct for him or his agents to argue that he cannot be arrested, this order notwithstanding, because they have an order, a previous order before this one by the EFCC?
Well, I'm having difficulty hearing you, but what I will repeat if I'm correct, and if I'm wrong, forgive me. But what I will say again, just as a point of emphasis, since I really didn't catch you, is that we cannot take laws into our hands. The EFCC cannot do that. If the EFCC were a party to the first order, issued by the first court, then it's bound by that order. It is not for the EFCC to say, all right, the time has lapsed and therefore we will disregard it and go on appeal or go to another court. I don't know whether that captures the question because I'm having great difficulty hearing you.
Okay, let me try again. I'm wondering, so does it mean that the order that the EFCC say they've got is not enforceable?
Which order now?
That they can arrest, that they have an order to arrest the former governor. The warrant of arrest was issued by the judge.
Which is not enforceable.
The warrant of arrest is not enforceable.
You mean the order obtained by the ex-governor?
No. The EFCC say they have a warrant of arrest obtained as a result of these proceedings. So the question is,
sure,
is that not enforceable?
Is the order obtained by given by the first judge enforceable? Is that what you're asking?
No, the one gotten by the EFCC, the warrant of arrest that the EFCC say they have, is it enforceable?
Oh gosh, the audio is really bad.
Oh dear.
Let me use my sorry.
Okay, well, we'll try and see if so the EFCC, is it better now?
Yes, sir.
So the EFCC say they have a warrant of arrest for the governor. Is that enforceable? I think you're muted or something because we can't hear you now.
It's so difficult.
Okay,
what you're saying.
It's coming through now. Okay, so the EFCC say, I'll give it one more shot. The EFCC say they have a warrant of arrest for the former Kogi State governor. Is that, in context of what you have said, is that warrant of arrest not enforceable?
The order given by the second judge?
Yes.
Are you asking if the order given by the second judge is enforceable?
The warrant of arrest that EFCC have.
Yes.
Is it enforceable?
Yes. In fact, if you ask me, I even wonder why the EFCC would need an order of arrest. You remember in the case of Emefiele, when he came before the siege of the Federal High Court, he refused. Is it necessary to have an order to arrest? It isn't. An order to arrest is simply administrative. So why did they go to the court in the first place? That's part of the confusion. The EFCC has power under the EFCC Act to take any steps, provided there's reasonable cause to arrest somebody on suspicion of commission of a crime. They are the ones who then made the mistake of going to another judge. If they hadn't, it would be different. But they went to another judge, and my point is that they can't do that if there is already pending an order before yet another judge. The question whether that order has expired or not isn't the issue. The proper thing to do would be to appeal, which the EFCC did, or to apply to set it aside, which the EFCC did not do. Rather, they jumped and went to another judge to get an order which, in my view, is not enforceable because they have violated the principle of you do not create confusion between two judges.
Pardon me, Mr. Agbakoba, let me just read this bit, which I think I skipped while I was reading that part. He says that because you, here you say that they went to another judge. But Mr. Kutekpa is saying here that he filed that application, which was overtaken by the decision of the same High Court of Kogi State, which made the orders in question. So it's not that they went to another judge. He's saying that they went to the same High Court.
No, but there were two different judges. There were two different. It's not the same High Court. Well, the same High Court, but two different judges, and each of the judges giving different decisions. That's the way I understand it. Look, listen, Chamberlain, this thing is so simple, it does not require any complication. You go to court, you get an order, rightly or wrongly, because we know judges make mistakes, to the extent that you've gone to court, and this is what the ex-governor did, an order to not arrest me. Again, I emphasize, rightly or wrongly.
Okay.
The EFCC is bound by that order until discharged.
Okay.
The EFCC is bound by that order whether or not it has expired. The EFCC ought not to take the laws into its own hands by even going to arrest the governor during the pendency of the order and going to another judge to get an order contradicting that of another judge. That is chaos. And I repeat, that is what the Chief Justice of Nigeria has frowned about and frowned against.
So the thing is, doesn't the same principle that you just stated apply for the order that the EFCC said they obtained? If the governor or his team don't like that judgment, shouldn't they also apply to vacate it and not prevent yourself from being arrested or offering yourself up for arrest?
I didn't hear a word of what you said. I'm so.
What I'm saying is, right, so doesn't the same principle of what you just explained apply in the EFCC's order against the governor? Can he then say, well, I won't obey this order, I won't offer myself up for arrest? Shouldn't they also go and seek to vacate that order as well, whether I obtained it rightly or wrongly, as you said? Okay. Maybe it's, I don't know if it's the connection here, but Kayla, go ahead.
I don't know if you can hear me. I mean, can you hear me, sir?
Clearly.
Okay. Now, I think I want to be able to talk a bit about something that you mentioned before, which is conflicting court orders and how the Chief Justice of Nigeria has spoken up against it. But we still see it happening, especially in this Yahaya Bello's case. I hear that today. Can you still hear me?
I hear you clearly.
Good. So I hear that today that we're going to be hearing about that case. That case is coming up at the appeal court today, the EFCC trying to vacate that high court order from Kogi State. But I want to be able to talk about the processes in general. Is there a reason why we still keep having conflicting court orders? Is it something that cannot be helped? Is it an inconvenience, but something that cannot be helped?
No. It's not an inconvenience. The rules are clear on conflicting decisions. You know, there are hierarchy of courts. The first is the First Superior Court of Record, the High Court, the Appellate Court, which is the Court of Appeal, and then the final court, which is the Supreme Court. In order to have coherence and in order to have sense in what the courts say, there is an understanding among brother judges that if my attention is called to the existence of an order, which if I make my own order will contradict that order, I will refrain from doing so because that order covers the field. So the order that the ex-governor got, again, rightly or wrongly, covers the field of the question of whether EFCC can arrest him. That's really the issue. And whether the EFCC could then go to another judge and get an order that conflicts with the order of the first judge is the cause of the problem. That's the cause. So we've been dealing with this problem at the level of the body of benches and saying to ourselves, how do we remedy this very difficult situation? It was all over the election tribunals. A judge would give an order here, another one will give another here, and that's the last thing that we want to see in the judiciary. And as I said, the CJN has continuously repeated to judges, please don't give conflicting decisions when you are aware that another judge has given a decision on the same point. Whether that judge is right or wrong is a matter for appeal. And the EFCC rightly exercised its constitutional right to appeal. And I believe the appeal is decided today or tomorrow. So why didn't the EFCC simply wait? To have gone to another judge was simply a huge error. Anyway, I have always taken the view, apart from what we're saying here, that the EFCC itself is unconstitutional. The EFCC is doing the job of the ICPC. The EFCC, as its name implies, is the Economic and Financial Crimes Commission.
Okay.
It is the ICPC. There's a difference between corrupt practices and economic and financial crimes. And in a particular case, the Supreme Court decided that the EFCC has gone way out of its remit. What is the EFCC doing with spraying of Naira? Is that the job the EFCC was created to do? So I think this is an opportunity for the Attorney General, who I know is very much concerned. And he said so when he was being, what's the word now, at the National Assembly, being questioned about his confirmation hearings.
We'll let you speak a little bit more on that particular matter, but we'd like to let our viewers know that there's a national dialogue on state policing happening in Abuja, which we'll bring to them now, but we will continue our own conversation here. But let me bring my colleague Ayo. He's got questions for you as well.
Thank you, Chamberlain. Mr. Agbakoba, there are so many questions to ask you, but perhaps by way of enlightenment, what is the difference between financial crime and corruption? Can you hear me, sir? Can you hear me, sir?
I can see you, but I can't hear you.
Oh, dear. Well, let me believe that that is being... Oh, wonderful. Thank you, sir. I just wanted to understand, maybe by way of enlightenment for the people, because every time we hear corruption, many people talk about money. Money is corruption. Of course, we all know that it's a lot more than that, but money seems to take the cake. So how does financial crimes differ from corruption?
Oh, money laundering, cybercrime, cryptocurrency issues, all the issues concerning what happens in the space, forged dollars. It's so clear. If you look at the Money Laundering Act, you will see the clear definition of financial crimes. And the question you ask is a great question, because that came up in the case of Joseph Mobike SAN versus the EFCC. And the court said, what are you guys doing here? It's not your job. This is the work of the regular law enforcement agencies. And I was absolutely, petrified by how far the EFCC was going, that I wrote a letter to the then chairperson, Mr. Bauer, and we agreed to visit. And I visited him, and I made clear to him that the EFCC has got way beyond its remit, and I would go to court if he did not resile from the unlawful things that the EFCC is doing. Well, someone intervened, and I said I'd rather go to the National Assembly. This may be the appropriate time, because the EFCC is way out of its league. It's doing all the wrong things. And I'm not suggesting that the EFCC hasn't done good things, but the EFCC is doing the wrong things when they are chasing after people that do not fall within their jurisdiction. Like, for instance, stealing. That is an offense under the laws of Lagos State. That is not the business of the EFCC. So that's my point. Let the EFCC concentrate on the definition of its function in its statute, economic and financial crimes. So the other one is the ICPC. They deal with corrupt practices. So at the very worst, if I was the lawyer of the governor of Kogi State, I would be saying that EFCC has no jurisdiction to even arrest me, because the relevant authority that should be dealing with my case is the ICPC. Public funds that are stolen amounts to corrupt practices, not financial crime. So the EFCC are even...
Yeah, just one more thing on that same one. So one of the things that one would wonder, so what exactly would you say that the former governor is being charged for? Financial crime or corruption?
I haven't read the charges. But if I were to surmise from all the drama going on, I would think it would be in relation to embezzlement of public funds. That's the way I would see it. I have no idea, because I haven't read the charges. But if I'm correct, that would fall under the remit of the ICPC, not the EFCC. And I think this would be a very good opportunity for the learned Attorney General, who's a very brilliant colleague of mine, to really take steps to set out the parameters of who does what. You recall that in one of the cases, I don't know where it was, I think Owerri, the EFCC and prison officials were openly fighting in court. openly fighting in court over authority.
Okay.
So this is the time to say who does what. And I strongly believe that the EFCC's power has been curtailed. And I will ask you, if you have a moment, to look into the decision of Joseph Wobike versus the EFCC. The EFCC's powers were constrained, very constrained. Say, keep to economic and financial crimes. Don't do crimes that the police is the power to do. And the serious front of the issued rightly or wrongly, it has veered from its own statutory parameters.
Okay. Well, another issue that's necessary perhaps for people to understand when you talk about conflicting judgments, people wonder, because on the one hand, someone will go to a state high court, another person will go to a federal high court, get these conflicting judgments. What's the difference between the two, and is any one of them higher than the other?
Equal. There are only three superior courts. There's the High Court, which could be federal, FCT, or state. They are all equal, concurrent. Then the appellate courts, and then the Supreme Court. So these are the three levels.
Okay.
So my point is, once a decision is given, as in this case, by a judge of coordinate, meaning equal jurisdiction, and you are aware. If you're not aware, that is different. But as I understand it, the judge who gave the second order was aware of the first one. So he ought not to. He would have said, look, I can't issue an order when there's an order from my brother saying that the EFCC should not arrest.
Okay, one last one.
Given an order that he should be arrested.
One other quick one. Yeah, my apologies. One quick one from me before we wrap this up, sir, is the process that this whole thing went, the process of going to the former governor's house. One of the arguments is, look, we should have gotten a letter of invitation, and then there was a siege on the former governor's house and all of that. So some are saying that if there was a letter of invitation, the former governor would probably have gone to the EFCC's office by himself, but then there is a siege on his house. So help Nigerians understand what the process or procedure should have been before we got into this drama, as you said.
I would not like to make comments on what I don't have original information. But all I'll say is that there's a process in the Criminal Procedure Code, even in the EFCC Act, for engaging people that you want to talk to. And you recall the case of the judges, where the DSS went to their houses in the night and broke all their doors. That cannot be civil. That cannot be allowed. So I don't know the facts of this case. But if you want to arrest somebody, follow the process. You either invite, or you don't even have to invite. My brother Femi Farada said that a letter of invitation has no place in the law. If you have enough evidence to invite somebody or request him to come, then you do so. But you don't just. I saw on TV over 30 armed EFCC people carrying guns. I don't think that is how to arrest people. That offends somebody's fundamental right to dignity. But I'm not an expert on this part of the question you ask. But generally speaking, it will be important that law enforcement agencies, not just the EFCC, show dignity when carrying out arrest orders. That would be what I would say.
Before you go, because many say he was charged for financial crimes, and so he can answer. Was the AGF wrong to have said he should turn himself in, and was EFCC wrong to have declared him wanted? Oh, okay. Well, I think we're out of time on this one. Because the AGF did ask him to turn himself in, and then the EFCC declared him wanted. So many wonder, were those two processes also wrong? Okay, we need to go, unfortunately. We do thank you for talking to us, Mr. Olisa Agbakoba, Senior Advocate of Nigeria. Well, that is the show today. We thank you all for watching. We'll see you tomorrow. I'm Chamberlain Uso. Goodbye.